Procedural advantage when process becomes power. This is Silence Screams Loud Strength, Unmasking Justice series. We are marking 5 years since domestic abuse was formally recognized as including coercive control, financial abuse, emotional abuse, psychological harm, and non-physical abuse. I am Samantha, your host. So let's begin. Honestly, 5 years. 5 years of this profound act being enshrined into law. And what has changed? I ask myself this question today, and I come with a heavy heart, but we have to name it and talk about it. So when process becomes power, justice becomes strategy, and strategy favors those who already hold control. So good day and welcome. Today marks a significant milestone. It has been 5 years since the law formally recognized what domestic abuse is not limited to physical harm alone. We now understand in law that abuse takes many forms: coercive control, financial manipulation, emotional harm, psychological harm, intimidation, restriction, isolation, patterns of behavior designed to erode a person's autonomy, confidence, and ability to make independent choices. That recognition was a vital step forward. But recognizing or recognition is not law. It's not the same as protection in practice. And as we look at how the system operates today, we must confront a difficult truth. Today's episode addresses a critical issue within family justice system and proceedings. Procedural advantage, not the law itself, not the outcome in isolation, but in the process, in conduct. Because in theory, procedure exists to ensure fairness. It is designed to create order, transparency, and equal footing for everyone who enters the legal system. It is intended to act as a shield protecting people from arbitrary decision-making and ensuring that cases are handled consistently, properly, and fairly. In practice, procedure can be navigated. And when it is navigated strategically, it can become a source of power. This is where the system must be examined carefully and addressed too, because justice is not only determined by what the law says, it is determined by how the process operates. And when the rules that are meant to protect fairness become tools that can be used to gain an upper hand, the very foundation of justice is put at risk. So what procedure is supposed to do today, or supposed to do in practice? The procedure is the framework that governs law proceedings. It is the set of rules that practices and standards that define how cases move from start to finish. It is clear expectation for everyone involved and ensures that no one is able to act outside the established boundaries without consequences. It sets timelines and deadlines. When documents must be submitted, when hearings will take place, and how long each stage of the process should take. It sets disclosure requirements from each party, what information must be shared between parties, and by when, so that everyone has access to the facts of the case in time. It sets hearing structures, how court sessions are run, what topics are discussed, and how evidence is presented within proceedings. It sets evidential expectations, what type of evidence is required, how it must be prepared, and what standards it must meet. In financial remedy proceedings, those that deal with money, assets, and finances following separation, is governed by the family procedure rules, including Part 9, Practice Direction 9A, and applied through Section 25 of the Marital Causes Act 1973. So these rules were developed with a clear purpose to ensure that both parties understand the case they are facing, both parties can respond to arguments and evidence presented, and both parties have access to the same information and the same opportunity to participate fully. This is closely linked to Article 6 of the Human Rights Act 1998, the fundamental right to a fair hearing. Article 6 is not just a legal concept, it is a guarantee that every person will be treated fairly, that their case will be heard properly, and that the decisions will be made based on proper evidence and proper process. But fairness is not achieved by procedure alone. It depends on how procedure is experienced. It depends on whether the rules work for everyone equally or whether they create barriers for some people while remaining accessible to others. So the rule book can look perfect on paper, but if it is not applied in a way that favors one side over the other, it fails to deliver justice it is designed to provide. So, when process becomes strategy, in contested proceedings where parties do not agree on the issues they are fighting for, different outcomes, process can become used as strategy, not unlawfully, not always improperly, but effectively. This may include actions that are technically within the rules, but which are used to create advantage, delaying disclosures, holding back information or providing it late, so that the other side does not have enough time to review it and prepare responses or seek advice. Extending timelines, requesting more time to complete tasks or agreeing to delays that push key stage further into the future, creating unnecessity and pressure, increasing document volume, submitting large amounts of paperwork, sometimes including information that is difficult to navigate or not central to the case, creating complexity and making it harder for the other side to process or understand the facts in issue. That's raising repeated procedural challenges, making objections, inquiries, or requests at every stage, which can slow the proceedings down and increase costs, requesting adjournments, asking to postpone hearings or meetings, sometimes at short notice, disrupting plans, increasing stress, and forcing the other side to rearrange their lives and commitments. Fragmenting issues across hearings, breaking down the complex matters into smaller parts so that the case takes longer to resolve, requiring more time, more legal work, and more resources. Individually, these steps may fall within procedural rules, but taken on their own, they may seem like reasonable requests or standard practice. But collectively, they can create pressure, they can create cost escalation, they can create unnecessity, they can create fatigue, pressure, constant uncertainty, and the feeling that the process will never end. Cost escalation, every delay, every extra hearing, every piece of additional work, adding up to higher legal fees, court costs, and expenses. Uncertainty, not knowing when things will be resolved or what step to take next, will create anxiety and making it hard to plan for the future. Fatigue over time, the effort required to keep up with the process, to respond to requests, and to manage the stress, taking a heavy toll on a person's physical and mental health. And that is a critical point, because the parties who can sustain the process often gain advantage at this stage. Not because they are right, not because their case is stronger, no, not because they can, but because they can actually endure the process. They are able to keep up, to keep going month after month, sometimes year after year, while the other side begins to run out of time, money, energy, or the ability to keep up. The health takes, your mental health and takes toll. When that happens, the outcome is no longer decided only by the facts of the case or by the merits of the arguments. It is influenced by who can last longer. That's endurance. So let's talk about the cost, time, and endurance. Litigation is not neutral. It is not a level playing field simply because both parties are subject to the same rules. No, it requires time, it requires money, it requires emotional capacity, it requires organizational abilities, time, attending meetings, reviewing documents, preparing statements, traveling to court, and managing the demands of the process. Money, so paying for legal advice, court fees, expert report, administration, cost, and other expenses. This all takes emotional capacity, coping with stress, uncertainty, conflict, and the pressure of going through a legal process. So, organizational ability, managing paperwork, meeting the deadlines, keeping track of the requirements of the whole process, and making sure all steps are completed correctly. Where one party has consistent legal representation and the access to professional advice, sufficient financial resources to cover the costs and arise, and the ability to continue proceedings over long periods without being forced to stop, or compromise, and the other does not. They are probably a litigating person, the process becomes unequal. This directly engages the principle of equality of arms, because equality of arms is not just a theoretical idea, it is a requirement enshrined in law. It is not enough to say that the rules are the same for everyone. True ability means that both parties have the practical ability to engage with process, to understand what is happening, to respond effectively, and continue participating without being pushed out. It means that if one side has access to expert support and the other does not, the difference in capability must be organized. It means that if the costs create a barrier to participation, that barrier must be considered. It means that if one party is exhausted by the process while the other party is strengthened by it, the court must understand what that imbalance does to fairness. If one party is forced into early settlement because of costs, delay, or exhaustion, then that process has influenced the outcome. They may agree to terms they do not want. They may agree to terms that are not fair. They may agree to simply because they can no longer afford to keep fighting. They may agree because they have had enough of the stress, uncertainty, and the procedural pressure. When that happens, justice is not served. It is not compromised by the way the process works. Procedural advantage in practice. So let's talk about that and explore a little bit further. Procedural advantage does not always require misconduct. It does not necessarily mean breaking the law or acting dishonestly. It emerges through differences in knowledge, resources, and capability. It is about knowledge of the system, understanding how rules work, what steps can be taken, how procedure can be used to achieve a particular outcome, and how to navigate the legal landscape. It is about familiarity with process, knowing what to expect, what is required, at what stage, and how to manage that requirement or requirements of the case and the facts in issue. It is about the ability to manage complexity, having the skills, the support, resources to handle large amounts of information, complex documents, and detailed requirements. It is about the ability to absorb costs, being able to pay for legal work, reports, expenses without that cost causing significant hardship or preventing participation. For example, late disclosure may require further hearing, additional legal work, and more time to prepare responses. Incomplete answers or unclear information may require a follow-up or follow-up questions, requests for clarification, and extra steps to get the facts right. So complex financial structures, business interests, or assets arrangements may require expert analysis, specialist advice, and extended periods of investigation. Each step extends the process. Each extension increases cost. Each cost creates pressure. And over time, the weaker party may disengage from the whole process, feeling that it is too difficult or too expensive to continue. They may concede points or agree to terms they do not support simply to bring the case to an end. They may settle prematurely, accepting outcomes that are not in their best interest, not because the case lacks merit, but because the process becomes unsustainable, unmanageable. This is particularly relevant when we consider the 5 years of progress we have made in recognizing domestic abuse beyond physical violence. For people who have experienced coercive control, financial abuse, physical, psychological harm, or other non-physical forms of abuse, this reality is often even more acute. These experiences can leave people feeling drained, lacking confidence, struggling to understand complex information. With limited resources to support themselves, it becomes profoundly difficult to navigate. When such individuals enter the legal system, they may face barriers that go far beyond the challenges of the case itself. They may face barriers created by how the process is structured. They may face barriers created by how the process is used. They may face barriers created by how process is experienced. And that matters, because recognition of abuse in law must mean recognition of the impact in procedure and process. It must consider participation. So vulnerability and procedural realities. This issue becomes more acute in cases involving domestic abuse, coercive control, and financial dependency. We have come a long way to understand that these forms of harm have profound effects on a person's ability to function, to make decisions, and to participate fully in life. Under FPR Part 3A and Practice Direction 3AA, the court is required to consider vulnerability. The law now recognizes that some people face greater challenges and that the system must adapt to ensure they are not disadvantaged in the process. But vulnerability is not only about the experience of harm, it's about function. It's about the ability to process information, understanding complex documents, legal terms, and what is happening in the case. It is about the ability to organize evidence, gathering presentation, and explaining information that supports your position or their position. It is about the ability to respond under pressure, making decisions, communicating effectively, and acting in your own interests when you are stressed, anxious, or uncertain. Where a party is experiencing trauma from abuse, conflict or financial restriction, or uncertainty and an imbalance of information, where one side knows more about the facts, the finances, or the system than the other, the procedural burden becomes heavier. Following rules becomes harder, meeting deadlines becomes harder, understanding legal documents becomes harder, responding under pressure becomes harder, keeping up the pace with the process becomes harder. And if that burden is not actively managed, if the system does not take these differences into account and take steps to level the playing field, the procedural advantage becomes structural disadvantage. This is a critical point. When people who have already experienced harm or disadvantage face further barriers because of how the legal process works, the system fails to protect them. It does not simply fail to deliver perfect outcomes. It fails to deliver fair outcomes. And 5 years after the law recognized the reality of non-physical abuse, the system must now recognize the procedural consequences of that abuse. A person affected by coercive control may not respond in the way the court expects. A person affected by financial abuse may not have access to documents. A person affected by trauma may not have the ability to organize documents quickly. A person affected by long-term psychological harm may not be able to withstand aggressive or complex proceedings without support. That is not weakness. That is impact. And impact must be recognized if justice is to function in the way it's intended. So, process versus justice. At this point, we must ask, what is the role of the procedure? Is it to manage cases efficiently, to keep up with the system moving, or is it to deliver fairness and ensure that justice is done. Because when process becomes the determining factor, justice is no longer purely legal. It becomes strategy or strategic. And strategy, by its nature, favors those with access to resources and professional support, knowledge of how the system works, and the ability to endure difficulty and difficult circumstances and to persist through challenges. That is the risk. When the way a case is handled becomes more important than the rights and interests of people involved in the process, the purpose of the law is now lost. Justice is meant to be about what is right, what is fair, what is just. But when process becomes power, the outcome can be decided not by what is right, but by who is the best able to navigate the rules and manage the complex and withstand the pressure. This is why the progress we have made in recognizing different forms of abuse is so important now. We now understand that harm can take many forms. We now understand that abuse can be financial. It can be emotional too, and it can be psychological as well. And it can be coercive, and it can be controlling. It can operate without physical violence. It can operate through dependency. It can operate through fear. It can operate through isolation. It can operate through process. And that is the part we must not ignore. Because if abuse can operate through process, then the legal systems must be alert to how process itself can become a continuation of control, harm, and all sorts of trauma. We must ensure that the system does not add to the harm. We must ensure that procedure does not become another barrier. We must ensure that people who need protection are not required to prove their strength by surviving a process designed without their vulnerability in mind. So let's be clear. The law is not the issue. The principles exist. The framework exists. The recognition of different forms of abuse and harm is now established, and that is a vital step forward. But the system must function. A justice system cannot rely on endurance as a measure of truth. A justice system cannot rely on costs as a filter for what is right. A justice system cannot treat delay as a neutral mechanism where delay can create pressure, fear, and collapse. Because when process becomes power, fairness becomes conditional of that power, and justice becomes uneven. We have spent 5 years evolving our understanding of what abuse is about and how it can affect people. Now we must ensure that the system is ready to support everyone who has come who comes to it, regardless of their circumstances, their resources, or their ability to navigate complex rules. We must now ensure that justice is not only just justice, a principle written in law, but a reality that everyone can access and experience. We must ensure that recognition becomes protection, that principle becomes practice, that law becomes lived reality. Because if the law recognizes abuse that procedure fails to account for, it impacts then the system that has only done half the work, and half protection is not enough. A system that depends on process without safeguarding meaningful participation and equal access will always favor those who can control it. The law is there to be followed.